Judge Stevenson.
With all
This is my first time
respect,
ever in life reading the rental card. This date happened August 13th. I came back down here.
the facts don't have a lot to do with me unless you want to go to me.
That's a rare moment of raw honesty from a defense attorney. When a lawyer says he's done everything he can and still can't work with the client, you know something behind the scenes has really gone wrong. What would you do if your own lawyer said this in open court?
Ultimately, it comes down to a conflict that is renders this attorney-client relationship unworkable at this point. There are issues ranging from allegations that the dates on various offense reports or rental contracts or things of that nature are wrong, to even more in-depth issues. And so our last in-person meeting devolved into a loud exchange, Your Honor. I don't know what more I can do in service of representing Mr. Cruz. I believe it's in his interest and the interest of justice that another attorney be appointed to represent him on this matter.
Okay, so what happened? What's the blow up that happened on the last? Because I don't expect defendants to be mistreated. And I certainly don't expect my lawyers to be mistreated.
Yes, sir.
That will have severe sanctions. It's dishonest. He's never been that way to me. You can put that way.
This is a document that says that I gave him a number. This is from the emergency response of T-Mobile. He tells me that the company says that there's no record of such. And the company, this is a subpoena that says, no, what, the attorney gave them the wrong phone number.
I can hold people in contempt of court because attorneys are going to quit wanting to represent people, and then good luck with the Constitution then if you can't be civil with a person who's working for your best interests. He's saying what he's saying. I don't believe him to be a liar and a man who is dishonest. He's never been that way to me. You can put that away.
This is a document that says that I gave him a number. This is from the emergency response of T-Mobile. He tells me that the company says that there's no record of such. And the company, this is a subpoena that says, no, what, the attorney gave them the wrong phone number.
Right there?
No, this is the wrong, he asked them to research the wrong phone number.
Okay.
And they saying that he gave them the wrong phone number. So that's not my phone number.
Okay.
And they say it's right here.
Are y'all trying to fix that?
It says, please have your attorney correct the target information.
Let him talk. Go ahead.
It says, please have your attorney correct the target phone number and issue a new legal.
Okay.
So they saying that I have a phone number with you.
Okay. Relax. Let me look at this. What's the? This is on August 11th.
Yeah.
Okay. T-Mobile hereby objects to the reference legal demand and is unable to respond, which is not service. Okay. You've seen this.
No, Your Honor, but we issued subpoenas for 2 different phone numbers based on our client's representations of what numbers belonged to him at the time. We received one affirmative response, to which we received a list of incoming and outgoing calls. I reviewed that with the client. He insists that—
Whoa, things just took a turn. We're hearing about car accidents, cancer, and supposed settlement offers, all mixed into a criminal case. The lines between civil damages and criminal defense are getting blurry here. And the judge? He's trying to make sense of it all.
other calls were made that are not shown on that record. The other phone number I subpoenaed was the number that was provided to me by my client in a number of different communications. This is just a series.
What about that?
Ongoing.
Did y'all receive information from the phone company on that?
As indicated, Judge, we received one response with records, and we received another response with regard to the other number that he provided, saying that there were no records associated with that number. There are issues regarding the contract that was executed.
Contract
Allegedly to rent a vehicle.
It's just the basis of this charge.
Which serves as the basis of this charge. There are issues regarding offense reports submitted by other agencies to the Department of Public Safety, in which the defendant alleges that the reports contain inaccurate information. It's not a workable relationship, Your Honor, and I would just again urge the court to appoint a different lawyer, perhaps who might be able to communicate with this defendant in a way that I seem not to be able to do.
Judge Stevens, with all respect, sir, this is what I want. This is what I seriously need. I want him to show you one document from the text dot police, from the text dot division. I was in an accident with Enterprise Run. I was hitting the video. In the text dot report, the text dot report is wrong. It says on that document, if an officer was if a Dallas police officer arrived at this scene, then what is their final conclusion in the narrative? It says that an officer is flagged down, which means I called Dallas police, which means Dallas police should have a police report. He's going to text dot instead of Dallas police. You have Dallas County Sheriff that recovered the vehicle.
And here it comes, the boiling point. The defendant interrupts, challenges, and pushes the judge too far. One word, contempt. In court, that's not just a scolding. It's jail time for disrespect. Watch how quickly this moment escalates.
And you have Dallas police who actually wrote the dude that hit the Enterprise rental car called driver side and passenger side damage to the car. I had counsel, I had a beat counsel in here, and I had a left hip injury. I'm trying to get, then he tell me this, Enterprise rental is offering me $170,000. I told him no. Then he say Enterprise rental is offering me $230,000. I told him no. You more worried about the civil instead of criminal. For them to be offering me something like that, let me get on the streets. I'm not absconded. I can go get my own records and I will show you. That's why I'm asking, can you please let me see that takedown report so I can present this to Judge Stevens.
So,
Okay. What do you say to that?
There is a text dot report that comes from the Department of Public Safety regarding the accident that took place in Dallas. The report date on the report is from August 24th, I believe, of 2023. I believe the state also has a copy of that document. It was submitted with the...
What was the day of the report?
The day of the report was August 24th. It was in the document.
Okay. So that's before this event occurred.
No, Your Honor.
The indictment says on or about October 2nd.
No, the offense report was made in October, but the offense itself, the initial rental took place on August 17th of 2023, which the defendant also indicates or alleges is an incorrect date. And again, Judge, I don't even know where these numbers about hundreds of thousands of dollars are coming from.
So look, with all due respect, Judge Stevens, this is my first time ever in life reading the rental report. This date happened August 13th. I came back down here.
The facts don't have a lot to do with me unless you want to go to me.
The judge finally lets the lawyer withdraw, calling it a relief. But notice his tone. It's not victory, it's exhaustion. Some defendants make every exchange a battlefield, and this one has worn down everyone in the room. What do you think? Fair decision or too harsh?
For a trial, you want a jury trial. It's for the jury to decide what the facts are. Right here, what I want is a defendant and the attorney to work together, unless you want to represent yourself.
That's another issue, Your Honor.
Is that right?
He alleges that he is entitled to hybrid representation. Judge, this is the offense report.
I don't need to see it. Hey, you know what?
Damn.
You know
so
what?
That means that it's a Dallas police report, and he refusing to go get it. That's
sit over there. You're in timeout, Mr. Rue. You're in timeout, Mr. Rue. My goodness. No, No, but we learned in first grade, don't speak over other people like you're doing to me. You want me to hold you in contempt? I can put you in contempt, and that would add time to whatever this is. Don't be rude.
I'm saying, how you say
Don't
that
be
you don't wanna
rude.
see it? That's
I just said, you're gonna have,
in my case. When you tell me I don't want to see that, you refusing my rights.
All right.
That's what you gotta do.
you're
That's
you're
all.
held in contempt. You are now placed back in jail until you can act properly, Mr. Rudeness.
I have a right to
Mr. Rudeness, go back inside. Thank you. All right. Yeah, well, you got your work cut out for you. What do you want to do?
I would like to withdraw from the case, Your Honor. The change that the defendant initiated with the court just momentarily is illustrative of every exchange that occurs in person between myself and the defendant.
Well, why would it be any different with anybody else, do you think?
Well, I have to believe that there is someone out there who can speak this defendant's language and make him understand.
English. Although it's a rude form of the English. All right, who's next on the trial? All right. All right, I'm gonna grant you relief. Put you out of your misery. But from time to time, we have treacherous clients. They're very difficult, but maybe another one will be have some better results from his responses, because he's obviously angry, and he certainly acts rude, and he certainly wants to control the situation on his terms, which is not the way the rules of evidence and the rules of law work. Everybody gets a fair opportunity to be heard, including him, but he can't overpower everyone else and try to control the proceedings by speaking over everyone and shouting. So hopefully, next person on the list.
At the end of the day, this case isn't just about law. It's about control, respect, and understanding the courtroom's rhythm. Every defendant gets a voice, but not the microphone. Would you handle a client like this differently if you were the judge? Let's hear it in the comments below.